Good afternoon, everyone. In a week it was, and in a week it is going to be. Before we start, kindly send me super thanks, subscribe, hit the like button, thumbs up, and let's grow the channel. Indeed, in the Senzo Meyiwa murder trial, it was a week of revelations. State called two witnesses who contradicted each other. Besides the fact that the state has been having these statements all this time, they could not see it coming. In actual fact, those two witnesses throw the state case deeper into crisis. How do you explain that as the National Prosecution Authority, who has the powers and authority to prosecute, they might not prosecute Ms. KK? It must be noted that this is the third state witness who implicates Ms. KK. Let alone that these statements are not made by the accused per se. They are made by these state witnesses. If we can all recall, in the trial within trial, the lead investigating officer read his affidavit statement into the record. It is part of these proceedings. Now and then, during the main trial, reference will be made to trial within a trial, because we cannot call the same witness again in the main trial to testify about what they did testify on in trial within a trial. It will be indeed a waste of time and resources. Therefore, it is my humble submission that the National Director of Public Prosecutions must intervene. It goes without saying that she might have had access to the docket, because they cannot give someone who is not a member of the NPA access to the docket, and they don't give to the National Director of Public Prosecutions. In the coming week, I wonder how will the state fix these defects. I am of the view that the state case will be thrown more into disarray. And it must be noted that it is not the accused who wrote down the statements. It is the state witnesses. Hence, they are called to testify on the statements they took down. Basically, it is their statements on behalf of the accused. They don't write the statements on behalf of the accused. It is their handwriting. And I wonder if the state did lay the basis for those statements. And it should have been established whether the statements were read back to the deponent first before the deponent could sign, and whether the deponent confirmed the contents of the statements, and is the deponent happy with the contents of the statements? Did the deponent make the statement without undue influence, without duress? Is what is contained in the statement what the deponent wanted to tell or narrate to the person who wrote the statement? Was the deponent happy with the statement? Then if the deponent was happy, is that the signature of the deponent? Then the deponent signs the statements. I wonder if indeed the state, before those statements were read, went through this process. If not, that's where the defense will summarize the state case when they call the accused. Because the accused will have to confirm that they were not under duress and they were happy with the statements, and the statements were made in their sober senses. And if the accused, the deponents, by any chance accept those statements and confirm them, they will be committing suicide. They will be throwing their own case, their own defense into disarray. Since all this time they've been saying they never made the statement, they never made statement freely and voluntarily. So at the end of the day, those confessions, they won't be admitted at the end of the main trial, when the court will be making a judgment with regard to the confessions before it can make a ruling in the main trial. That will be the end of the state case. I do suspect that the state is buying time. The state is buying time in this matter by not charging those people who were in the house. The state is maybe under the impression that whilst they are buying time, something might happen to save them, the state. Because to be honest, they messed up big time on this matter. And now we are wondering who's next. Who's the next whom they are going to call as a state witness? And how will that person cure the defects in the state case? With due respect, I think there's no way that the state can now cure their case, because there are so much contradictions. It can also be recalled that under trial within trial, Kininda never mentioned monies paid to the accused persons. In actual fact, he even rebutted and refused that he has any kind of budget that even mentioned the amount of 3 million. He rebutted those claims that he works on the budget to pay the accused. And further, even those state witnesses who testified who were in the house in the main trial, they never mentioned any money in a container. even Kininda never mentioned any money in the container which were taken by the accused. In fact, what the state tried to do and show, they come up with photos of monies in a plastic bag, and they claim that same photos were found on the phone of accused number 4 and Miss KK, of which I did previously submit that the defense should have objected to those kind of questions, because the rights of the accused were violated when their phones were taken. There was no such application before the Honorable Court. Just like now we're going to Swaziland, what's happening in Swaziland? There is an application before the Honorable Court which must be heard with regard to the confiscation of cell phones of the accused persons. And in actual fact, such application was supposed to be done before they even take those cell phones. And the state in Swaziland was trying to commit an irregular step by taking those cell phones and give them to the South African police before even such application can be made. And moreover, such cell phones were confiscated in Swaziland. The South African Police Services doesn't have jurisdiction in Swaziland. Once those issues come before a South African court, it will be an issue of a trial within trial. It will be a constitutional issue as well. As you are all aware that the state in Swaziland and the defense there, they are waiting for the South African government to file their extradition application. I heard the spokesperson of Department of Correctional Justice and Correctional Services that such application must be drafted by the NPA. Then NPA give it to the state, the South African Department of Justice and Correctional Services, who together with Department of International Affairs and Cooperation and the National Government of South Africa will submit such documents to Swaziland to make such an application, which shows that indeed there is a relationship, and the NPA, the police, Department of Justice and Correctional Services, they are in one pot. The NPA was supposed to be independent from the Department of Correctional Services and Justice. Remember, these two departments were combined. Now it is called Department of Justice and Correctional Services. The NPA is supposed to be seen to be independent. Moreover, it is the same Department of Justice, Constitutional Development and Correctional Services that give the judiciary budget. Hence, the previous Chief Justice argued that the judiciary must be completely independent from the Department of Justice, Correctional Services Affairs. The Department of Justice, Constitutional Development and Correctional Services, they are supposed to be separate from the NPA and the judiciary. Hence, the Honorable Justice Mokoe argued that the budget of the judiciary must come directly from the Treasury, even though still The Treasury is the part of the South African government, but it must be operating in such a way that it can be separated from the department. Just like other institutions like the Public Protector's Office, Women and Human Rights Commission. Justice must be only be done. Justice must only seem to be done, but it must also be seen to be done. Justice must not only be done, but must also be seen to be done. The 1928 case of R versus Hepworth. But now we have a problem here. To make things worse, the NPA, the judiciary, and the Legal Practice Council, they all report to one portfolio in government, in the parliament. They all report to one portfolio. Portfolio on justice and constitutional development. They are in the same pot, even though the LPC was supposed to be completely independent from the government, as it represents. It alleges that it represents private legal practitioners. But it is my respectful view that the LPC overlook at the affairs of the legal practitioners. It doesn't represent legal practitioners. Hence, we have different bodies of legal practitioners, and I wonder why we must pay so much money for membership fee, annual fee to the LPC. All these amounts were supposed to go to Law Society of South Africa or different bodies representing legal practitioners. The LPC doesn't report to legal practitioners, doesn't hold annual general meetings for legal practitioners or with legal practitioners, but it reports to the same state. But we, legal practitioners, must subsidize the same legal practice council. These laws are really confusing and they need to be fixed. Justice must not only be done, but it must be seen to be done. Let's go to the matter of Daniel Malesela Teffo. He's coming back to court on the 20th of March, a day before Human Rights Day, a day before the celebration of human rights. And we hope that he will be assisted with regard to bail. What a shame. This is the week of human rights. People are in custody for such a long time without giving an opportunity to apply for bail. Now what our government do? Our government rushes to the International Court. That's what our government does. It rushes to the International Court and raises the issue of human rights and genocide intent. Genocide intent, whereas here in our own country, we still have to deal with the issue of violation of human rights. Whatever the medicine is given to the South African government in the international arena, it seems as if it's karma. It seems as if it's chickens coming home to roast, because it's the same treatment some people are receiving here in our country. Just for example, we have water crisis. This week, it has been water crisis in Johannesburg and some parts of Pretoria. Water is a human right, basic one on top of that. It's a basic right. It's a fundamental human right, and it must not be violated at all costs. I hope this government will fix this issue of water as soon as possible by yesterday. Now, let's go to the matter of Thabo Bester and Makudumana. As I already touched the matter in Swaziland, wherein the hearings are also coming next week with regard to the issue of extradition application and whether the South African police must be allowed to confiscate those phones in Swaziland. On the issue of Thabo Bester and Nantipa Makudumana, I'm of the view that their rights had been violated. That is my respectful submission with regard to the issue of production house flighting some documentary with regard to them, especially to Thabo Bester. No one says these individuals didn't have the right to make a documentary or to make a living, but rights come with responsibilities, and they must be limited unless there is an agreement between the parties, which it will include Thabo Bester and Makudumana and this production house, and they are going to somehow compensate them for using their name. Just like that documentary of Mary Ndlovu. She needs to be somehow compensated because they used her name to make a lot of money. Just like the documentary of Senzo Meyiwa made a trial, which was flighted days before the trial had begun. They made a lot of money out of that documentary, and people whose names were used or pictures were used and their families need to be compensated if they are not up to so far. Lastly, let's go to the most sad story in the country with regard to the disappearance of children. The disappearance of child JS, in inverted commas, in Cape Town. And I do believe that the South African police services must work with the communities to try and locate the child. And I still have confidence in some of the members of the police. As we all know that in each and every field, there are bad people and good people. I've noticed that the Commissioner of Police in Cape Town, in the Western Cape, is on top of his game. And it looks as if he's a person who knows what he's doing, who needs the support of the community, but the community must not disturb the police when they are doing their work. And I would like to condemn the scuffles that broke out outside the Cape Town court when the accused who were arrested, the mother of the child, and the other 3 who appeared on this matter of child JS in inverted commas. And I'm happy that if the state doesn't have any evidence against someone, they withdraw charges. However, my concern is they are not supposed to flood their faces. The media are not supposed to show their faces because they might put their lives in danger. Like, for example, now, charges against the lady was withdrawn. Charges against the lady were withdrawn, whereas the lady has already been flighted and he slept a few days in custody. That put her life in danger and the life of her family members. The police must not leave no stone unturned. They must go into the compounds. They must go into compounds of churches and look for the child and other missing children. Who knows, maybe they can find other missing children in these compounds of some of the churches, especially even those churches who preach that they have the best interests of the children and they want their children to be successful and have a prosperous future. The police know where to go. They must go. And no one can stop the police from investigating. As long as the police have proper papers and they follow proper procedure. The police need to be supported. This is not the first case to happen about the disappearance of a child, especially in the Cape Town area or Western Cape area. In some instances, the police were not allowed to enter some compounds. The police need to exercise their rights and their duties and apply for proper papers to enter where they believe that the crime might be committed or is being committed, or crime might be resolved. People must stop hiding around the bush. People, especially in positions of power, must not pretend as if they don't know what's happening in our country with regard to the disappearance of children. They must have the right. They must have the right to go wherever they want to go and look for those children, as long as they do everything within the confinement of the law, confinement of the Constitution. The Constitution is the supreme law of the country. Even honorable courts, when they make rulings, they need to consider the Constitution. The Constitution comes first. We know there is we know that there is jurisprudence and also case law, but those case laws or rulings or decisions or precedents that came before 1994, before the supreme law of the country, before the Constitution, they must be put against the Constitution and tested whether they will stand the constitutional master. That is very important, because we cannot be living in 1910 or 1956. Whereas we say, no, we are now changed, we are in the Constitution. All these case laws, they must be tested and check if they pass the constitutional muster. And I hope that justice will be done. What is justice? What is justice? Justice is two-way. Justice is not a one-way traffic. Justice for the victims and justice for the accused. It might happen that wrong people are being accused and they won't get justice. It might happen that people who are supposed to be accused are outside there, and the victims of the crime, including family members, they'll never get justice. People who are in positions of authority and power need to do the right things and look at this word justice as defined in our Constitution, and will have a well-taken care society. Our society must be well taken of. Just like people, they go to International Court of Justice to seek justice. We all come before the honorable courts to seek justice. Hence, we refer to the presiding officers in the High Court and the Constitutional Court as justices. Because in them, we trust, believe, and hope that justice will be handed down. Sithembele kubo ukuthi sithole justice. I hope you understand, and wish you a good week and happy celebrations of Human Rights Day. I thank you.